A Michigan family owed $2,242 in back property taxes. Their home was worth, by the county's own assessment, $194,400. The county foreclosed, sold the home, and the family walked away with nothing, not even the difference between what they owed and what the home was actually worth. 3 years ago, the Supreme Court seemed to promise that could not happen anymore. On June 23, 2026, the Supreme Court ruled again, unanimously, in a way that quietly guts a big part of that earlier promise. If you own property, or you know someone falling behind on a tax bill, this ruling changes what actually happens if that debt is ever allowed to snowball into a foreclosure. Quick thing before we get into it. I break down Supreme Court rulings that affect your actual finances, not just abstract legal theory, the moment they are decided. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into exactly what changed. To understand this ruling, you need the case that came before it. In 2023, the Supreme Court decided Tyler versus Hennepin County, a case involving a 94-year-old Minnesota woman named Geraldine Tyler. She owed about $15,000 in back taxes, penalties, and interest on a condo after an original tax bill of roughly $2,300 ballooned over time. Hennepin County seized the condo, sold it for $40,000, paid off the $15,000 debt, and kept the remaining $25,000 for itself. The Supreme Court ruled unanimously that this violated the Constitution's takings clause. The government can seize your property to satisfy a genuine debt, but it cannot pocket more than the debt is actually worth. Any leftover equity belongs to the homeowner, not the county. This became known as the home equity theft ruling, and it was treated correctly as a major, unambiguous win for property owners nationwide. Here is the problem Tyler left unanswered, and it is exactly the problem the court just addressed. Tyler said homeowners are owed their surplus equity. It did not say how to calculate that surplus. Is it based on the home's actual fair market value, what a normal buyer would pay through a normal sale? Or is it based on whatever price the home happens to fetch at a tax foreclosure auction, a very different kind of sale that often produces a lower price than the open market would? That gap is exactly where the Pung family's case landed. Their Michigan home, the one the county's own assessor valued at $194,400, was sold at a tax foreclosure auction for just over $76,000. Under Tyler, the family believed they were owed the difference between what they owed in taxes and what their home was genuinely worth. Isabella County argued the relevant number was simply what the auction actually produced. Here is what the Supreme Court decided, unanimously, in an opinion written by Chief Justice Roberts. The benchmark for just compensation after a tax foreclosure is generally the price the property actually fetches at a fairly conducted public auction, not an estimate of what it might have sold for through a conventional listing on the open market. In practice, this means the Pung family and homeowners in similar situations going forward are not entitled to the gap between a county assessor's market value estimate and the tax debt owed. They are entitled only to the gap between the tax debt owed and whatever the property actually sold for at auction, a number that is very often meaningfully lower than true market value, sometimes dramatically lower, exactly as it was in this specific case, where the difference between the assessed value and the actual auction price was well over $100,000. I want to be precise about what this ruling does and does not do, because getting this wrong in either direction misrepresents a genuinely nuanced outcome. It does not overturn Tyler. The core principle from 2023 still stands. A government cannot simply keep all the proceeds from a tax sale and give the homeowner nothing back. What Pung does is narrow how much that principle is actually worth in practice by defining the baseline for calculating the surplus as the auction price rather than the home's true market value. For a homeowner whose property sells at a fair competitive auction for something reasonably close to its actual worth, this distinction may not matter enormously. For a homeowner whose property, like the Pung family's, sells at auction for a small fraction of its real value, this ruling means the surplus they are entitled to recover shrinks dramatically, potentially by well over $100,000 in a case exactly like this one. There is one meaningful door the court left open, and it is worth understanding clearly because it is where any future fight over your own specific situation would actually happen. The ruling specifically conditions its ruling on the auction being fairly conducted, and it sent the Pung case back down to the Sixth Circuit Court of Appeals rather than resolving everything itself. That remand leaves room for homeowners to still challenge a tax foreclosure sale if they can show the auction process itself was flawed, inadequate notice, procedural shortcuts, a rigged or non-competitive bidding process, anything that would mean the auction price itself does not reflect a genuine, fair market test of the property's value. In other words, the fight over the underlying calculation, market value versus auction price, is largely settled now in favor of auction price. The next fight, over what actually counts as a fair auction, is very much still open, and it is likely to be where homeowner protections in this area actually get litigated going forward. So here is what you should actually do with this information if property tax debt is a live concern for you or someone you care about. First, and most importantly, this ruling makes prevention dramatically more valuable than it already was. Once your home is sold at a tax auction, the amount you can realistically recover, even after Tyler and even after this ruling, is now tied to the auction price rather than your home's real value, a number you generally do not control, and that is often considerably lower than what your home is actually worth. If you are behind on property taxes, contacting your local tax authority about a payment plan or exploring assistance programs many counties and states offer for exactly this situation is worth doing well before any foreclosure process begins, not after. Second, if you are already facing a tax foreclosure, or you know someone who is, understand that the fairness of the auction process itself is now the more promising legal question, whether proper notice was given, whether the bidding was genuinely competitive, rather than simply arguing your home was worth more than it sold for, since that second argument is exactly what this ruling just closed off. Third, keep an eye on your own state's specific tax foreclosure rules, because in the wake of the 2023 Tyler ruling, a number of states already passed their own reforms strengthening surplus equity protections beyond the federal constitutional minimum, and those state-level protections are not touched by this federal ruling at all, meaning your actual protection may be stronger than the federal baseline depending specifically on where you live. Step back and look at what this two-case sequence, Tyler in 2023 and Pung this year, actually tells you about how the Supreme Court builds out a legal principle over time. Tyler established the headline principle in dramatic, sympathetic terms: a 94-year-old woman, a county pocketing tens of thousands of dollars that was not theirs. Pung, decided unanimously by the same 9 justices just 3 years later, took that principle and answered the much less dramatic, much more technical question of how to actually calculate it, and the answer it gave meaningfully narrows the principle's real-world value for homeowners whose properties sell at auction for well below true market value, which, based on how tax foreclosure auctions typically function, describes a meaningful share of the cases this entire line of rulings is actually meant to protect. If this helped you understand a ruling that could genuinely matter to your own finances or a family member's, hit like so it reaches other homeowners who have not heard about this yet, and subscribe if you have not, because there is already congressional attention on this exact issue, with the House Oversight Committee pushing for reforms, citing Tyler directly, and I will be tracking whether that translates into any actual legislative response given how much Pung just narrowed the underlying protection. Tell me in the comments whether property tax debt has ever been a real concern in your own family, because that tells me exactly how much practical state-by-state detail to build into a follow-up video on this exact topic.